You take me through your sort of legal training and the steps in your legal career a bit, because I'm not familiar with what tends to happen in that way.
The ordinary drill was and still is that you spend a year with somebody as a pupil, the somebody being an active practitioner whose practice basically you shadow. So you go with him or her to court and you read all their papers and you sit in their room and you have complete access. You sit there throughout their conferences and so on. And in those days you paid a fee of 100 guineas. Now I think now a pupil isn't allowed to do any work of their own if anybody is rash enough to instruct them. In those days you could, so that if anybody did instruct you, you could do it. I began with a very engaging character called Owen Stable in January of 1959. The head of the chambers was a very leading silk at the bar, who since later became even more famous, called Leslie Scarman, and they were a very good set of chambers to be in.
Which ones were they? What were they called?
They were actually called Mr. Scarman's chambers.
This is Lord Scarman.
Yes, yeah. But he became a judge about a year later. However, I was actually extremely fortunate because at Easter he gave a party. I went to it and I was trying to be very nice to everybody. And after Easter, he said, "It looks as if you're going to have to come into chambers because my wife says you must." So I was really treated as a member of chambers from then on, although I'm not formally sort of painted up on the board. But you spent a year, and I did a certain amount of work during the year, but when I wasn't doing any work of my own, which was most of the time, I did whatever Alan Stable was doing, and used to draft a lot of pleadings for him. And he was very encouraging because he tended just to sign them and send them off to get typed.
But what sort of pleadings were they? I mean, what sort of cases? These are civil cases?
Yes.
Yes.
He had an extraordinarily varied practice, so that I think that was my pupillage. We visited sort of courts at every level in the land, from magistrates' courts and county courts to the appellate committee of the House of Lords, and one saw virtually everything sort of happening. I should have mentioned, because this is actually quite important to me, that during the period of qualifying for the bar, I spent 3 months marshalling for a judge, which he was on the Northeastern Circuit, and we began in Newcastle in January and went Durham, York, Leeds, Sheffield, where we finished at Easter. The thing with the marshal is that he lives the life of the judge, stays with him in the judge's lodgings, is present at all meals, sits with the judge on the bench, discusses the case with the judge. And so one did this for 3 months, seeing criminal cases being tried and civil cases being tried. And I personally found it hugely instructive and educative because, in the first place, you had the ability to form judgments as to whether people were doing things well or not well. And secondly, and even more significantly, one got the judge's reactions to everything. And the judge I was with, who on the face of it was a very austere, teetotal, sort of Baptist of rather forbidding appearance, actually was the most compassionate and and delightful and generous man. And one found that he was extremely human in his reactions. And it sounds a curious thing to say, but I found it extremely reassuring at the outset of one's career to find that somebody who seemed to belong to a completely different sort of generation and have a different outlook, etc., was actually a human being with whom I could relate perfectly easily.
What was his name?
He was called Donald Finnemore.
Mm.
He hadn't been a huge success. He was an intelligent man, a very intelligent man, very good Queen's Bench judge. Rather, probably a bit lazy, really, but that's not a bad thing.
Will he mind you saying that when he sees it, or he's dead now, I suppose?
Oh, he's been dead for some time.
Yes.
But he didn't set up all night researching cases that counsel hadn't cited. No, he was. He was an absolutely excellent judge.
Why do the judges go on circuit?
Because since the time of Henry II, they have. The king then decided that he would dispatch his royal justices round the shires to administer royal justice, and then when they had travelled round the circuit, they would return to Westminster, which was their base. The system has survived partly because there's a very strong feeling that if you were just to have a sort of high court judge, you do of course have circuit judges stationed locally, but there's a strong feeling that if you were to have a high court judge who was in Durham or Newcastle or so on, he would not, or she, have the same chances of promotion and of being recognised as judges who were sitting in London under the gaze of the authorities and so on and so forth. I once proposed that you should station High Court judges around the country on a sort of semi-permanent basis, rather like bishops, so that you'd have, as it were, a diocesan High Court judge. But this was colossally unpopular. And everybody just thought it was going to sort of privilege the London elite. That may be right.
Did you feel any sense, or have you ever felt any sense of pride in being a member of an institution that dates itself back to Henry II at least and before, and has this very strong traditional structure going back so far and being so different from other legal systems?
Are you talking about the judges or,
yes.
the practitioners? The judges?
Yeah.
I think the judges do certainly have a sense of belonging to a very small elite. We have a very tiny judiciary compared with most people. I think about 1,000, probably more if you count in immigration judges and so on, sort of full-time paid judges in this country as compared with 35,000 in the United States, which is not 35 times as big. I think this is certainly true, and I think the fact that it is a small and rather carefully selected number contributes to the fact that its record of sort of behaviour is extraordinary. There is very, very little misbehaviour, and there's been a pass in 1701 in the Act of Settlement to dismiss a judge on redress by both Houses of Parliament, and this has never happened in relation to an English judge. It happened once in relation to an Irish one, which means that there is really just no history of corruption or anything like that.
Is the fact that, I don't know if it's still the case, that until recently anyway, 97% of criminal cases were settled at the level of the magistrates. So we have a huge unpaid, informal judicial system? Is that part of the reason we have a small...
Absolutely, it certainly is. It certainly is. Because you've got a large number of lay magistrates around the country. I would have known the figure once, probably 30,000 or something like that. Yes, absolutely, that is a reason.
And are they an important part of the legal system?
Hugely important. Crucial. Yes. I mean, one of the functions of the Lord Chief Justice is to go around and address bodies of magistrates periodically all over England and Wales. And I think I certainly regarded it, and I think other holders of the office have regarded it as sort of token to maintain the self-belief of the justices.
Mm.
And to make them feel appreciated, which they certainly are.
Mm. Let's go back to your career after marshalling.
Yes, I'm sorry. That was, of course, before pupillage began.
Yeah. And then pupillage, and then what happened?
Well, then I became a member of Chambers.
Yeah.
And then one did whatever work came along.
Mm.
We had, in my chambers in those days, a very, very wise and also extremely unmercenary clerk who was, the presiding providence in Chambers, really, who guided everybody's careers and was a great sort of judge of form and I mean, he could be a very severe critic. I can remember him once saying, coming out of court after watching me do something and saying, "Whose side did you think you were on then, sir?" But he was a very wise and entirely disinterested person who would sort of take decisions on one's behalf and say, "I think it would be a very good idea if we sort of refuse all work in the county court from now on, because I think we should be concentrating on the High Court," which is a big thing. And then the time came when he said, "I think it would be a good idea if you were to apply for silk this year." And one always followed his advice. And he always made decisions in one's own interest rather than his own. And of course the clerk had an interest in those days because he was entitled to 10% of anything you earned, so quite clearly he had a vested interest in you earning as much as possible. I mean, our man would say there are two briefs on offer. One is marked X for so-and-so, others were marked 10X for somebody else. You'd do much better to take the brief marked X, because these are much more useful solicitors to have a connection with. But it's a matter for you, which do you want to do?
What you said, he suggested you apply for silk. What does that mean?
In those days, it meant that you put in an application to the Lord Chancellor saying you wanted to become a Queen's Counsellor. And it's become hugely more complex since. But in those days, you had to get, I think, a couple of judges to support you.
What age were you at this time?
I was 38.
That was pretty young to apply.
Yes.
And you found two judges who supported you?
Yes, I mean, Cyril, the clerk at Chambers, said, "I'll ask Milford Stevenson, who'd been the head of Chambers before." Milford was always very supportive on these occasions. He had done cases in front of him. And he said, "Well, I think I can get the Lord Chief Justice to support you, that would be good." So he approached the Lord Chief Justice and Hubert Parker said, "Well, I make a point of not supporting individual candidates," but he said, "I shall see the list when it comes round and I remember the name." So I can't remember who I got for the other one.
And you got your silk. And
yes.
How did that change your life? What do you What do you have to do then?
Well, it changed your life quite substantially because it meant that you didn't settle pleadings anymore. You always had a junior who settled pleadings. It meant you...
What is the settled pleading? Sorry to ask.
Well, writing the document that consists of your claim or your defence or whatever.
Yeah.
I mean, some of these... I mean, that sounds like a very simple bit of paper, but it isn't necessarily. Get them going on for pages and pages and pages. And of course it meant that you had to go to court with a junior, so it meant you were only instructed in cases that were sufficiently important to somebody that they were willing to spend that amount of money.
So you didn't settle pleadings, but you were now speaking in court. That's your main function.
Yes, of course, one had been doing that before, but it was to an even greater extent than stopping trade. Yes, and of course you were advising.
And this was still mainly civil business.
Yes, in my chambers we used at the beginning to do some criminal work that was extremely ill paid, and the practice was to give it up as soon as you could, really. And so after the first 3 or 4 years, 3, 4, 5 years, one didn't really do any more criminal work. Except very unusually.
How long did you remain at this sort of level?
As a silk? I was a silk for 8 years.
And did you counsel the Queen?
Well, I acted for the government quite a lot, if that's the same thing.
At that time?
Yes.
As Queen's Counsel?
Yes.
In what way?
I had been all rather esoteric, this standing counsel to a department as a junior, which meant that you remained in private practice, but any litigation that the department was involved in, they instructed you. So I did have quite a close link with the Department of Employment. And in the early 1970s, when, if you remember, the Industrial Relations Act and the huge turmoil in the industrial relations field, it became actually quite a lively area. And so one got involved in a lot of rather high profile work, which led to a sort of government connection. I also spent a year as a silk investigating how oil got to Rhodesia during United Nations sanctions. If you remember, when following UDI in Rhodesia, the United Nations imposed an embargo on the supply of oil, which was meant to bring the country to its knees. And this didn't happen, and the oil was getting there. And so David Owen, when he was the Foreign Secretary, was prevailed on later to establish an inquiry to ascertain, investigate how the oil had got there. And so I and another chartered accountant were given this task. It was interesting.
And you found out?
Yes, we did.
And reported? And
yes. It became actually quite clear. I mean, there were 5 companies that were potentially involved, and 2 of which were American, Mobil and Exxon, one of which was French, CFP, and 2 British companies, BP and Shell. And the Americans and the French told us to get lost, and we had no powers to compel them to cooperate in any way. So it ended up as an inquiry basically into Shell and BP. And what was of interest, I think, certainly to me and to my partner in the investigation, was whether Shell and BP were going to cooperate in presenting their evidence to us. Because if they did cooperate, it was going to be quite easy for them really to be economical with the truth and tell us as much as they wanted us to know and no more. Whereas it was obvious that if neither of them knew what the other was telling us, they would have to be rather more forthcoming. And it became quite clear that there was no cooperation between them at all. And indeed I had a conversation just within the last fortnight with somebody who'd been very senior executive in Shell at the time, and I touched on the subject and he said, well, you're quite right, there was no interchange between us and BP, whatever.
Sound like prisoner's dilemma.
Quite interesting.
Yeah. So after those 8 years or so, what was the next stage in your career?
Well, the next stage was to become a Queen's Bench judge. And that, in those days, nowadays it's all different, and you apply, but in those days it was a system known in the trade as the tap on the shoulder, which meant that the Lord Chancellor tapped you on the shoulder and said, I'd like you to become a judge. And there were always some people who said, well, I don't want to, or I can't afford it, but there were very few in those days, and most people said yes.
And what was the job of a Queen's Bench judge?
Well, it meant that you spent part of the time sitting in London. And
in which court? In the Queen's Bench?
Well,
was that still existing?
In my case, it was usually in the commercial court, because I was appointed to the commercial court, having latterly done a lot of commercial work, which really means shipping, but it's a bit broader than that. And we would also spend some time travelling around the circuits, doing whatever work came your way, but certainly doing quite a lot of crime. So that you would be trying murderers and rapists and things like that, as well as hearing civil cases and then going to London to hear commercial cases.
And did you enjoy that period?
Yes, I did. The commercial court was a small body of about 6 judges with a very strong esprit de corps, and it was a very successful court. I mean, it is a very successful court. And it's a very proud boast. It's quite a dollar earner for the country. It's a very proud boast, the commercial court, that over half the cases involve no British company or individual at all. So that there are people who are choosing to sort of litigate in this country. So there are considerable benefit of the profession in the City of London.
Is it a court which has a jury system?
No.
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 But when you went on circuit, you had juries?
Yes.
And what do you think of the, it's rather a strange question, but there have been suggestions from this government particularly that we should restrict the number and situations of jury trials. What is your feeling about that?
I think almost every Queen's Bench judge and almost every circuit judge is a strong proponent of the jury system, for a number of reasons, one of which is that the public have enormous confidence in juries. They would just much rather be tried by their fellow citizens on questions of did he do it or didn't he, than by a single judge. And it wasn't my experience, and I don't think it's most people's experience, that juries come up with sort of absurd verdicts. I suppose sometimes they would acquit people that one thought were jolly lucky to get away with it. I don't recall cases where they convicted people one thought should have been acquitted. So I suppose that the tendency to lean in favour of the accused just, but I think would nowadays depend very much on what crime they committed. And I don't think there would be much leaning in favour of somebody accused of paedophile offences, for example. No, I would, very much in favour of juries. I did make myself very unpopular at one stage by advocating that there's a certain class. I mean, there are some cases which can only be tried by justices and some cases which can only be tried by a judge and jury. But there's an intermediate class of cases that can be tried either way. And under the system which I think still obtains, and certainly did obtain, the defendant had an absolute right to choose. So that if you were accused of, to take the traditional example, stealing a bottle of milk, you could demand a jury trial at enormous expense to the public. Because a jury trial, however short, costs quite a lot of money. And I proposed that this is a decision that should be taken subject to appeal by magistrates. And they should say, we consider this is fit for jury trial, or we don't. And then the defendant, if he thought he could challenge it. But this was very, very unpopular, and it hasn't happened.
And what about, one accusation is that juries are incapable of dealing with very complex matters, i.e. very complex financial matters, and therefore they shouldn't be involved in such cases. Do you think, did you find such?
I never myself actually tried a long fraud trial. I've been considerably impressed by the argument advanced by at least some of those people who have, that the sheer sort of physical difficulty of managing a big fraud trial with 12 jurors in a jury box makes the whole thing inappropriate, because you get, perhaps dozens of bundles of files of papers, and it is a very considerable problem as to how physically you accommodate these, quite apart from the extreme difficulty of tracing complex financial transactions through in front of a jury. There's another school of thought that says at the end of the day the question's always a very simple one, however complex the factual background, was he honest or dishonest? And that's probably true. I've some sympathy with the view that fraud trials can't be very well managed in front of juries, but I wouldn't want to extend that very far.